Hi friends, good evening. Welcome to UPSC World. This is Dr. Harinath Reddy. As we all know that today UPSC preliminary examination paper 1 got over, and I hope all of you have done this exam so well. So before I discuss answers for the questions on Indian polity, you have an important announcement. So after the prelims exam gets over, what next? If you want to score very high in the mains exam, you all know that linking current affairs in your answers in GS paper 2 and paper 3 and also in the PSR optional is very important. So we at UPSC World are starting a free current affairs program for UPSC mains 2025. So all those who are interested can get enrolled in this program by contacting us. Then let's get started about the polity questions. I have not seen the entire question paper, but at least those questions which have come on Indian polity, they are easy questions, not very difficult. Let's take the first question. This is question number 26. Consider the following statements with regard to pardoning power of the President of India. Statement 1. The exercise of this power by the President can be subjected to limited judicial review. This is a correct statement. There was an important case, Epuru Sudhakar versus State of Andhra Pradesh. This is the case in which the Supreme Court has said that pardoning powers can be subjected to judicial review. Of course, the power of judicial review, though limited, the pardoning power can be subjected. So this is a right statement. The exercise of this power by the President can be subjected to limited judicial review is a right statement. The President can exercise this power without the advice of the central government. This is a wrong statement. Pardoning power is not a discretionary power of the President. Pardoning power is to be exercised by the President on the advice of the Union Council of Ministers headed by Prime Minister. So the second statement is incorrect. Let's see what is asked in the question. Which of the statements given above is or correct? So the first statement is correct. So the answer is 1 only. Let's move to the next question. Consider the following statements. On the dissolution of the House of the People, the Speaker shall not vacate his or her office until immediately before the first meeting of the House of the People after the dissolution. This is a right statement. According to the provisions of the Constitution of India, a member of the House of the People, on being elected as a Speaker, shall resign from his or her political party immediately. This is an incorrect statement because the anti-defection law says a person who becomes the Speaker, if he is interested, he can resign to the political party to which he belongs to. So if he does that, he will continue to be the member of Lok Sabha. But it is not mandatory for a person to resign to his political party once he becomes the Speaker. It is voluntary. It is left to the discretion of the person. If he wants to resign, he can resign. If he doesn't want to resign, he need not resign. If he resigns, he doesn't lose the membership of Lok Sabha. So according to the provisions of the Constitution of India, a member of the House of the People on being elected as Speaker shall resign from his or her political party immediately, not required. This is an incorrect statement. The third statement, the Speaker of the House of the People may be removed from his or her office by a resolution of the House of the People passed by a majority of all the then members of the House, provided that no resolution shall be moved unless at least 14 days of notice has been given of the intention to move the resolution. This is a correct statement. Speaker, Deputy Speaker, Chairman, Deputy Chairman, they are all removed by effective majority. A majority of the total membership of the then members present and voting. So, which of the statements given above are correct? 1 is correct, 3 is correct. So, the answer is 1 and 3. Question number 28. Consider the following statements. If any question arises as to whether a member of the House of the People has become subject to disqualification under the 10th schedule, the President's decision in accordance with the opinion of the Council of Union Ministers shall be final. This is an incorrect statement. A question of disqualification is decided by the Speaker or the Chairman, that is the presiding officer of any of the houses. This power is not given to the President. So this is an incorrect statement. There is no mention of the word political party in the Constitution of India. This is an incorrect statement. In the 10th schedule, in the anti-defection law, for the first time, the term political party is referred to. So which of these statements given above is are correct? So 2 only is the answer. Consider the following statement. Statement 1. In India, state governments have no power for making rules for grant of concessions in respect of extraction of minor minerals, even though such minerals are located in their territory. This is an incorrect statement. When it comes to minor minerals, the state governments does enjoy the power for making rules for grant of concessions. Statement 2. In India, the central government has the power to notify minor minerals under the relevant law. I think that this is an incorrect statement. And if you see the options, which one of the following is correct in respect of the above statements? Both statements are incorrect, but you don't have this option. Let's see what UPSC will give as an answer for this question. Next question, question number 31. With reference to the Indian polity, consider the following statements. An ordinance can amend any central act. This is a right statement. An ordinance can abridge a fundamental right. This is an incorrect statement. Fundamental rights cannot be amended through ordinance. Fundamental rights can be amended only through a constitutional amendment act under Article 368. So second one, incorrect. An ordinance can come into effect from a back date. So this is also a right statement. Retrospective implementation, what we say. Which of these statements given above are correct? So 1 and 3 are correct. Question number 32, consider the following pairs. Arunachal Pradesh. So with respect to the state of Arunachal Pradesh, the capital is named after a fort. Yes, there is a fort called Eta. So the capital city Itanagar was named after a fort Eta, and the state has 2 national parks. So this is a correct pair. Nagaland. The state has come into existence on the basis of a constitutional amendment act. This is incorrect because Nagaland was created through the reorganization of Northeast India through an ordinary law made by the Indian Parliament. So second pair is incorrect. Third pair, Tripura. With respect to Tripura, initially it was a Part C state. It became a centrally administered territory with the reorganization of states in 1956 on the basis of Fazal Ali Commission, and later attained the status of a full-fledged state in 1987. So the third one is correct. How many of the above pairs are correctly matched? 2 pairs are correctly matched. Question number 33. With reference to India, consider the following. So he has given 3 bodies: Interstate Council, the National Security Council, Zonal Council. How many of the above were established as per the provisions of the Constitution of India? Only 1, because Interstate Council is a constitutional authority which is created under Article 263. The other 2 are not created under the provisions of the Constitution of India. So the answer is only 1. Question number 34. Consider the following statements. The Constitution of India explicitly mentions that in certain spheres the governor of a state acts in his or her own discretion. This is a right statement. Unlike the President of India, governor does have constitutional discretion. Though he had a constitutional discretion, it's not wider jurisdiction. It is a limited jurisdiction. Second statement. The President of India can, of his or her own, reserve a bill passed by a state legislature for his or her consideration without it being forwarded by the governor of the state concerned. This is an incorrect statement. Article 200 says, if the powers of the state high court are affected, such a bill passed by the state legislature can be reserved for the consideration of the president by the governor. The president cannot place it for his consideration by himself. The second statement is incorrect. And there was an important judgment recently in 2025 April. So which of the statements given above is are correct? 1 only. Question number 35. Consider the following pairs. Provisions in the Constitution of India and a stated goal. Separation of judiciary from the executive in the public services of the state. It is part of the directive principles of the state policy. Correct pair. Valuing and preserving of the rich heritage of our composite culture. It is part of fundamental duty. This is also a correct pair. Prohibition of employment of children below the age of 14 years in factories. Fundamental rights. This is also correct. How many of the pairs are correctly matched? All the 3. Question number 36. Consider the following statements. With reference to the Constitution of India, if an area in a state is declared as scheduled area under the 5th schedule, what will happen? The state government loses its executive power in such areas and a local body assumes total administration. This is an incorrect statement. The state government doesn't lose its executive power. the state government continues to have executive power. But the administration of the 5th schedule areas is in the hands of the governor. The governor has the responsibility for the peace and good governance of the 5th schedule areas. The governor can be advised by the Tribes Advisory Council headed by the Chief Minister. So this is an incorrect statement. The union government can take over the administration of such areas under certain circumstances on the recommendations of the governor. This is again an incorrect statement. There is no such provision in the Constitution of India under Article 244 Clause 1. Which of the statements given above is or correct? Both are incorrect. Which of the statements given above are correct? It is, the answer is D, neither one nor two. Question number 38. Consider the following subjects under the Constitution of India. List 1 is Union List in the 7th schedule. Extent of executive power of a state. Conditions of the governor's office. If you take the first two, if you want to make any change to any list in the 7th schedule, if you want to make changes to the extent of executive power of the state, such an amendment shall be done by the parliament by special majority, that is a majority of the total membership and 2/3 of the members present and voting both in Lok Sabha and Rajya Sabha. In addition to this, half of the states must also give approval. For a constitutional amendment with respect to which of the above, ratification by the legislature of not less than one half of the states is required before presenting the bill to the President of India for assent. So the answers are 1 and 2. Question number 39. With reference to the Indian polity, consider the following statements. The governor of a state is not answerable to any court for the exercise and performance of the powers and the duties of his or her office. This is a right statement. We all know that India is a parliamentary democracy. The real power is with the State Council of Ministers headed by Chief Minister. Though all the decisions are made in the name of the governor, but the governor doesn't take any decision. So he is not answerable to any court of law for whatever decision made in his name by the State Council of Ministers headed by Chief Minister. No criminal proceeding shall be instituted or continued against the governor during his or her term of office. This is also a right statement. Members of a state legislature are not liable to any proceedings in any court in respect of anything said within the house. All the three statements are correct. Which of the statements given above are correct? 1, 2, 3. Question number 41. Panchayats at the intermediate level exist in all states. This is an incorrect statement. So the 73rd Amendment to the Indian Constitution very clearly says, in all the states where the population is less than 20 lakhs, the panchayat at the intermediate level need not be constituted. So incorrect statement. To be eligible to be a member of a panchayat at the intermediate level, a person should attain the age of 30 years. This is also incorrect. Any panchayat at the district, intermediate, at the village level, the minimum age is 21 years, not 30 years. The Chief Minister of a state constitutes a commission to review the financial position of panchayats at the intermediate level and to make recommendations regarding the distribution of net proceeds of taxes and duties leviable by the state between the state and the panchayats at the intermediate level. So the Constitution does not confer such power on the Chief Minister. This is also incorrect statement. Which of the statements given above are not correct? So all are not correct. So the answer is D, 1, 2, 3. Question number 48. Consider the following statements about Lokpal. The power of Lokpal applies to public servants of India but not to the Indian public servants posted outside India. This is an incorrect statement. The power of Lokpal extends to the public servants within India and who are posted even outside India. This is an incorrect statement. The chairperson or a member shall not be a member of the parliament or a member of the state legislature of any state or union territory. To this extent, the statement is correct. If you see the second part of the statement, only the Chief Justice of India, whether serving or retired, has to be its chairperson. This is an incorrect statement. Even a judge of the Supreme Court, serving or retired, can become the chairman of the Lokpal. Even an eminent person can become the chairperson of the Lokpal. So if you take the statement as a whole, this is an incorrect statement. The chairperson or a member shall not be a person of less than 45 years of age on the date of assuming office as the chairperson or member as the case may be. This is a right statement. It is laid down in the Lokpal Act of 2013. Lokpal cannot inquire into the allegations of corruption against the sitting Prime Minister of India. This is incorrect. Lokpal can inquire into the sitting Prime Minister, but there are certain exceptions. Which of the statements given above are correct? So here only the third statement is correct. So the answer is A. So that's it about the questions which have come on Indian polity and the answers to them. And I am again repeating, your prelims exam got over. What next? What next is for you to score very high in your mains exam. So entire PSA are optional. Part paper 1, paper 2, polity part and the IR part, it is totally current affairs based. GS paper 2, paper 3, current affairs based. If you want to score very high in the mains exam, you need to link current affairs as part of your answer. So we take that responsibility of helping you in helping you to learn current affairs, to add value to your answers without taking much of your time. So with a limited time, taking limited time from you, we will try to cover comprehensively all the current affairs of last 1 year, and you can try to score high in the mains exam. So those who are interested can contact us, and the classes will get started from June 8th of 2025. Thank you and all the best.